have to. The third school bill, Howard County 1, is just being held for this meeting, but we're going to address it at a subsequent meeting. We're going to end this meeting at 9:45 to allow members of the House delegation to get to the State House for 10 a.m. session. And with that, we will need to bring up the Howard County Bill 222, which needs an amendment. And so I turn to Senator Hester for that.
Thank you, Delegate Watson. The amendment has been emailed to all of the staff and all of the delegation. It basically just puts the sunset on the bill for a 5-year term.
Move the motion.
Second. Does anyone have any questions on the sunset provision that's being added to this bill? Okay, will you please call the roll?
Delegate Terraza has her hand up.
I'm sorry. Thank you. Delegate Terraza?
Yeah, just real quick question is, I mean, we may have discussed this last week and I'm just forgetting, but why are we putting a sunset on it?
The sunset was requested by the teachers union, and it's just
okay.
to make sure that everything is working. And so we revisit it in 5 years.
Okay, thank you.
Ms. Rubling, will you please call the roll?
Sure. Senator Lamb,
Yes.
Delegate Watson,
Yes.
Senator Gazzoni. Don't believe he's here. Senator Hester,
Yes.
Delegate Atterbury,
Yes.
Delegate Eversole. Sorry.
Yes.
Thank you. Delegate Feldmark,
Yes.
Delegate Hill,
Yes.
Delegate Kittleman,
Yes.
Delegate Novotny,
No.
Delegate Pendergrass, believe she's absent. Delegate Terraza.
Yes.
Motion passes.
Thank you. We will now move on to Howard County Bill 922. We do have members of, we have the superintendent, Martirano, here with us.
We moved the.
Sorry.
We moved
Do we
the
need a paper
amendment.
with
Don't we need to move the bill? I'd like to move the bill. Didn't we just move the amendment?
I apologize. Yes, we
I'd like to
voted
move
on
the
the
bill as
amendment.
amended.
Let's move the bill.
I'd like to move the bill as amended.
Second.
Ms. Rubling.
On the bill as amended, Senator Lamb,
Yes.
Delegate Watson,
Yes.
Senator Gazzoni, I believe, is absent. Senator Hester,
Enthusiastically, yes.
Delegate Atterbury,
I said yes. Can you hear me?
Yeah, I can hear you now. Sorry about that.
Okay.
Delegate Eversole,
Yes.
Delegate Feldmark,
Yes.
Delegate Hill,
Yes.
Delegate Kittleman,
Yes.
Delegate Novotny,
Yes.
Delegate Pendergrass, I believe, is absent. Delegate Terraza.
Yes.
Motion passes. Thank you.
Okay. Now that we're finished voting on that bill, we move on to the next school system bill, which we do have Dr. Martirano here and other members of the school board and staff for any questions. Howard County Bill 922 is at the request of the Board of Education of Howard County, who since 2019 has presented an initiative legislation to us seeking the authority to think sort of outside the box when it comes to offering a continuum of learning. The idea is sometimes called reimagining time, sometimes called blizzard bags, but it is important right now for the ever evolving educational landscape, and especially given the COVID-19 impact and what that's done to brick and mortar instruction. Howard County 922 amends Education Article 7103 to allow Howard County to use alternative non-classroom based instruction to count towards the 180-day requirement. These types of models are defined under the bill as synchronous or asynchronous instruction delivered outside of a classroom, including through virtual classrooms, paper packets, or other learning experiences that do not provide in-person instruction. And the Board of Education may adopt a policy on the use of alternative instruction models for school closures due to various emergency situations, such as hazardous weather conditions, disease epidemics, physical constraints such as damage to school buildings and utilities, or a law enforcement emergency. The policy must include alternative comparable instruction for students or staff who do not have internet access. Finally, the board and bargaining unit for the teachers must negotiate the terms and use and implementation of alternative instruction models to ensure that all who are impacted by the bill agree on how and when it is used. Ultimately, this bill gives the school system flexibility to provide a quality educational experience to students in Howard County when in-seat instruction is not possible. And Dr. Lamb, I'm going to turn this over to you to chair since this is my bill.
Sure. So thank you, Chair Watson. So for this bill, let's see if we can open up for discussion of a motion.
Move approval.
Is there a second?
Second.
All right, so we can, it's been properly moved and seconded. We can open it up for discussion. Happy to take questions. We have Dr. Martirano, as Chair Watson mentioned, is available to answer any questions. I see hands raised from Delegate Terraza, followed by Delegate Hill, and then Senator Hester in that order. Delegate Terraza?
Thank you, Mr. Chairman. I have a number of questions about this bill. I think we all have seen the need for some type of alternative instruction, but one of the concerns I have, so there's a lot of conditions under which this could happen and no limits in terms of the time frame. So for example, if there's damage to the building, there's nothing here that says you have to make alternative accommodations like this. It seems to me like under this bill, there could be damage to the building and then we could go into this alternative instruction mode indefinitely. Am I reading that wrong?
Either for Dr. Martirano, the sponsor. Go ahead.
Let me answer that. Good morning, delegation, and I'm enthusiastically here to talk about this bill as well. Delegate Terraza, I oftentimes use the expression operational impact, so that if we were looking at a specific school that needed to have an adjustment based upon a flood or a fire or something to that effect, that would cause me to react to close that school to provide an alternative learning model.
Right, but in terms of,
yep.
yeah, I apologize because I have a number of questions and I don't want to, I know we have a number of bills, but would there be a limit on that time? I mean, my concern is it says damage to school building, but in the past when there's been damage to school buildings, like in, I forget whether it's Glenwood Middle or what have you.
And my response would be that would be case by case. Some would require, only a day. Some may require more than 5 days to provide that alternative model. So I wouldn't want to pen in a time restriction, particularly pertains to a school. I want that flexibility to be able to use a virtual education to help us address those situations. It wouldn't be time bound.
So one of my concerns that I would say to my colleagues is that right now, what they do, my understanding is that if you have some of these types of emergencies in a single building, I mean, obviously, if you've got a disease epidemic, that's different. But if you have a damage to a building or otherwise, they make alternative arrangements and I guess the kids end up in another building. Is that?
That could be one of the possibilities.
Right. Yes. And I worry that some of those kids would instead end up in this alternative instruction model. And so that gets me to the alternative instruction model, which I wonder if somebody could talk to me about asynchronous instruction. What does that mean? And how is that different than homework?
So synchronous instruction, if it were
Asynchronous, yeah.
asynchronous, would be that the student would be guided directly using Canvas as our platform for teachers to post assignments, and students would do that on their own as independent learning. So it's another alternative model for the teachers to engage with our students on.
Can you tell me how that's different than homework?
So if we didn't have the continuity of having young people in front of us and assigning that homework, we could assign homework on the Canvas platform and make those one and the same. But if we were out for an extended period of time, the student would post that, the teacher would post that information on Canvas and have the flexibility to do so. So you could view homework as the same, it would just be delivered in a different way.
Can I chime in on that?
Go ahead.
So I've actually done like the flipped classroom model, which is you record yourself doing a video and the kids watch that video at night. So it is a lot, asynchronous would be more akin to self-learning, and then with check-ins with their teachers. So homework is usually, which you understand to be traditionally homework. You're in a classroom, you learn the material, you go home, and then you practice what you learned independently. In an asynchronous assignment, it could be flipped around, where the learning is happening by whatever model the teacher is choosing to deliver. It could be a recorded video lesson or something like that. And so there is more self-learning happening in the asynchronous model, and then the practice is happening as well.
Thank you, Ms. Watts. I actually really like the flipped classroom model where they learn with a video at home and then come in and do work in the classroom. But that from having a child in school during some of this asynchronous learning isn't what I saw at all in any of his classes. It was more homework that was assigned. And for some of our students who have more challenges with independent learning and homework, I felt like that added to, that made it much more challenging. So I guess my concern is any asynchronous learning that would go on for an extended period of time. And the other question I have is, why are we adding paper packets to this list? It says paper packets or other learning experiences that do not provide in-person instruction. Why not just strike paper packets and say other learning instructions that do not provide, other learning experiences that do not provide in-person instruction? I guess I'm wondering why we are weighing in on a particular method of teaching. What comes to mind is some of the paper packets my kids have taken home, and some of the things that I've talked with my interns about and other students who call paper packets busy work. I'm assuming you're not talking about busy work, but
Well,
I'm wondering why we add that to the list.
I want to be able to have the flexibility to respond to any particular situation. And there have been times, Delegate Tarasa, where we've had to use paper packets this year to fill in some gaps where there was not necessarily the access for the virtual learning to occur. So I want to be able to have that flexibility of paper packets, virtual learning, the use of our Canvas website, so that in the event that we are closed for a period of time, I could be able to provide those alternatives. We just use that as a comprehensive nature of the things of which we can provide.
Isn't that the same as other learning experiences that do not provide in-person instruction?
Technically it is, but specifically we put those in as examples.
You put just paper packets in as an example.
Because that's the main alternative.
Okay, I guess that is part of, do you have evidence that those paper packets are effective in some way in terms of teaching?
For example, when we were building up to switch from virtual, we had no other option but to provide those. So the evidence is that that could be perceived as busy work or substitute work that would, in terms of emergency plans. But we viewed that as keeping the continuity of instruction and having something to fill the gap in the temporary period so we could switch to virtual. I'm not a real strong advocate of the paper packets, but it provides a gap for us to fill until we can get to the level of virtual.
So I see
yeah.
there are a few other questions from other folks. Maybe we can give others an opportunity and then come back if they aren't answered as part of the other questions that were asked. I see, and thank you, Board Member Watts, and I see Board Member Catronio is also here joining us this morning, along with Dr. Materano. So Of the hands raised, we have quite a few now. Delegate Hill, followed by Senator Hester, followed by Delegate Eversole, in that
Okay.
order.
Thank you, Mr. Chair, and thank you, Delegate Watson, Chair Watson, for this legislation, and Mr. Superintendent, school board members for being here. So my questions are really in two directions. The first is having, a year and a half, almost 2 years now into our virtual hybrid, learning model. And what I'd like to know is what would this legislation do to allow you to switch basically, in a moment's notice or in very short notice that we weren't able to do for the snow days, right? So we've had snow days, you've learned how to do hybrid and virtual, and yet we weren't able to do that this past month. So how does this bill help do that? And number two, this talks about emergency situations where a particular school or schools are shut down. Would you not want this model also to improve our home and hospital model? Don't we have students who've been having to learn outside the classroom, and traditionally they haven't been learning very well. The instruction has not been really good, and wouldn't some virtual components being added to that be helpful in that situation?
So thank you for that question. And I'm going to go back to Delegate Watson's introductory comments to the bill, which are contained in it, based upon what the Educational Article 7-103 says, that all schools must be open for pupil attendance for 180 days. And then the issues associated with where that guidance comes from the state superintendent and MSDE. What I'm advocating for is to allow us to have the flexibility at the local level to be able to shift to snow days, to have the policy developed by the Board of Education and in conjunction with negotiations with our unions, so that we can encompass the issues of which you have talked about, so that we could give teachers the notice defined by policy. But as it exists now, Delegate Hill, that local control does not exist. That's more dictated at the state level. And I'm seeking the support to have that as another tool to allow us to do what you had just presented. But the main piece that I'm most excited about in this bill, that it goes back to the development of the conversation between the superintendent and the board developing the policy, and with the negotiations with the union that would take into account everything that you just said.
Okay, then let me have this follow up just so that the public is clear and I'm clear also. The reason that this year, when we had snow days, we didn't switch to virtual is not because we didn't have the technological ability to switch on short notice. It's because the state would not allow those days to be counted, or both. Yeah.
Right now, that is correct. Right now, the way that it is, our calendar has additional days built in to meet the 180-day requirement. So to bring it to real time, Delegate Hill, we have used 4 days of snow days that we did not switch to virtual, that now I've tacked on to the end of the year, that is already baked into our calendar, that end up being days that are not productive. So if we have the ability to switch to virtual, I can keep the continuity of instruction proceeding, have a more predictability of our schedule, and build it from that level. So that is correct.
So let me, I think maybe I didn't ask the question right, and then I'll let this go. Could we technically have done it? In other words, even if it wasn't going to count towards the 180, could we have said to our kids this year, did you need to do an additional negotiation with the teachers? Did they not have the ability to plan for a possible snow day? Could we have done it this year from a technical operational standpoint if it were not for the fact that it wouldn't have counted?
We technically, right now, we're not prepared to do that.
So there is some technical component that still needs to be.
And other we'd have to work out with our teachers in terms of preparation. So yes, sorry I didn't answer that more specifically. Thank you.
Okay, thank you.
All right, thank you, Delegate Hill. Next, we have, I think it was Senator Hester, followed by Delegate Eversole. Then, if no further questions, back to Delegate Terrazza. Go ahead, Senator Hester.
Thank you, Chair Lamb. So last year, I want to fully support this bill. Last year in committee, when Garrett County did this, I asked about adding Howard County on.
Right.
I was told by committee staff that Howard County, I don't know, it was very, very confusing, but I was told that Howard County already had the ability to do this, as did Garrett County, and the law was just kind of silent on this issue. So it sounds, given the previous conversation, that we've just clarified that we cannot count the days. And so this bill, is necessary for any county that wants to do this. Is that correct?
It is my interpretation that we need the clarity to allow us to fully do this, to meet compliance with 180 days, that because it states that schools must be open for pupil attendance for the 180 days. This provides more clarity to that, so that there's no confusion about whether we can or we can't do it.
I see. So it's just confusing at this point.
I'm seeking the clarity for that through this bill, and then allowing us the flexibility to do it on an as-needed basis. Yes.
Okay. And if other counties try to hop onto our bill, what do I do?
Well, I quite frankly, I would advocate that I think every county in the state should have this flexibility, and that this should be a statewide bill. We have to take care of our boundary, which is Howard County, and we're the first ones to step out. I do know that there is interest from other superintendents to see how this proceeds.
Right. Okay. Thank you. So, well, is it different than, did Garrett counties not do this?
I can't remember
Take
specifically.
it offline.
Yeah, I can't, I don't have that one in front of me, but I know that superintendent well, and I know there's great interest there too.
All right, thank you, Senator Hester. Next, we have Delegate Eversole. I see Delegate Novotny also raised his hand. We'll come back to Delegate Terrazza at the end. Go ahead, Delegate Eversole.
Real quick on the Garrett County, it didn't pass, obviously. It didn't have any of the protections in it that this bill seems to have. And so that was a problem. It treated the issue as as I repeat, the flipping of the switch, that at 5:45 in the morning, where teachers are going to flip the switch and their lessons are going to become online lessons. And the idea of having teachers prepare in advance for this doesn't work, because instruction changes each day. And so you need, oftentimes your lesson is varied the next day based on what happened the day before. Teachers put in emergency lesson plans at the beginning of the year, but those are only for emergencies, and those are busy work to keep kids from, give kids something to do during those times. I also will say, I know Dr. Martirani didn't mean this, that those days are you said there's nothing useful happening, something useful, but I would submit you're right. Perhaps a little more useful during the year than at the end of the year. I know that we strive very hard to make those days significant.
Yes.
At the end, even though it's much harder because of the general feeling. Mike, I do have a question though, and that was before I heard a couple of the other things that we talked about. This is sort of a response to large school closings like snow days or COVID, all the sorts of things that we had difficulty with, excuse me. But now we're starting to talk about individual school closings. And so this happens. You have schools where a water main breaks and it's closed for 2 days. How does the state react to you on that if that particular school isn't open the requisite 180 days? Are you able to ask for waivers for that situation? Because I'm not sure that this bill should apply to those kind of closures, sort of as Delegate Terrazza was getting at.
Well, the expectation is on those days, and I've had several of those in the past, is that the instruction is made up once those days are re-engaged. We inform the state typically of those, and then the requirement is, because we're not adding specific days on at the end of the calendar for a specific school, that we work real hard to scaffold the support and making up the continuity of instruction that we need to do at that day. But there is not that requirement based upon an emergency for that one particular school to have to go an extra day longer. It is our job locally to ensure that the instruction occurs.
So based on that, I wanted to just throw out the idea that this be targeted at full school closings or approximately full district closings. Just an idea, and you can respond, or I just wanted to toss it out there. But that's more what we're aiming at here, in my opinion.
That is correct, but Delegate Eversole, as we're going down this path, my board the Board of Education, Howard County, always asks me, what tools do you need to run the school system most effectively? And that the virtual environment provides another tool for us to meet the needs of our young people. So yes, I agree with you, but then also we never in the past have not had the ability to go virtual. We didn't have that tool. This may be a tool that we can utilize and leverage in a way to provide support for those individual schools that close down too.
Thanks, Dr. Martirano. Thank you, Mr. Chair.
Can I add one thing to that? So one of the things we are actually also looking at is more targeted responses to things that happen in the school system. So if we have an outbreak or something at a school, as we've seen over the past break, over the winter break, we could actually focus on taking that one school to virtual, right? So we wouldn't really want to say that we have to do this system wide when we could take a much more targeted approach to how we serve each individual population of schools.
Correct.
All right, thank you, Delegate Eversole. Thank you, Board Member Watts. Next, we have Delegate Novotny, followed by Delegate Terraza.
Thank you, Mr. Chair. Generic question along the same lines is, can you imagine a time, Doctor, when we might close the school down in a similar fashion to what we did at the beginning of this pandemic? If there was a pandemic 2.0, can you imagine using this bill, this legislation to shut down a school for 6 months or a year at a time?
Well, I surely hope not, based upon the fact it would have to be specifically driven. I mean, what we just came through with March of 2020 was just, unprecedented, and we all had to shift to that environment. We've learned so much since then as we're managing the pandemic. We're basically in the endemic stage with it, and I've made it very clear that school should be the last place to close. Based upon everything that we've learned with our vaccination rates, et cetera. But I never say never. So if that's the case, if it were one particular school, I'd really have to isolate that down and understand why we would close that particular school. That may be an environmental issue that we would have to close that school down for mold or something such as that. And then I would relocate our young people into a different environment. But I could not imagine a situation where I would close a school for 6 months, an individual school, without an alternative placement for a child in the normalized education system.
Thank you. And then the follow-up question, and maybe this is for the rest of the team to think about too, is have we thought about the impact to working families, working parents, where we might have 1, 2, or a month off of school, a specific school? Have we jumped into that idea at all?
Well, I would consider all of that on a case-by-case basis with the Board of Education, and parents are always at the top of our mind in terms of how we respond to any event because we recognize the impact on families. And that has been a critical variable revealed during the long periods of virtual, the great impact for childcare, for the emotional well-being of our students and family as we close for extended periods of time. So again, we have enough information that we know how to respond differently, but an individual school would present a whole different set of circumstances that I would be looking at individually with the Board of Education.
Thank you, Doctor. Thank you, Mr. Chair.
All right, thank you. All right, so I think everyone's had a first bite at the apple. We'll go back to Delegate Watson.
Go ahead with Delegate Eversole and Delegate Terraza, and I'll wrap up.
All right, back to Delegate Terraza and then Delegate Eversole for quick follow-ups here.
I think,
Go ahead, Delegate Terraza.
sorry, I'm having trouble unmuting myself. So Dr. Martirano, did you say we'd be the first county to do this?
We would be the first county to have this kind of bill that designates the specifics that we talk about with the engagement of our Board of Education, the policy, and our unions. Yes, ma'am.
Okay. To be clear, I wouldn't want us to do anything that would interfere with a school's ability to close for a pandemic. I just want to be very clear on that. I want us to be able to do that.
Yeah.
And to be able to do alternative instruction. I guess my concern is mainly what's spelled out in here, and that there's no limit on how much of this asynchronous, which I think was very, very difficult for quite a few of our students. And I really think if we're going to move forward with this, I would like to see an amendment to pull out paper packets, because I just don't think we as a delegation, and we as the state should be weighing in on paper packets that I don't think, I think that without that, you still could do paper packets. I think you do paper packets as it is. You know, I have my concerns about this. I agree with Delegate Ebersol that the individual school closures sound like it's different. It sounds like you already have the ability to do that and it not count against the number of days. But I have my concerns about this, but I would at least like to see us take out paper packets, because I just think anytime we weigh in on that type of instruction, I think that's a problem.
Okay. All right. Thank you, Delegate Terraza. We have Delegate Watson.
I think, did Delegate Ebersol go?
He lowered his hand.
I just
You wanna
I hadn't lowered my hand. Sorry about that.
Okay.
Oh, all right. Go ahead.
Delegate Ebersol, as a teacher, I'm just curious about your opinion on whether or not it's bad to have paper packets in the legislation.
Well, what concerns me, I think I sort of alluded to it, is that when this idea originally came, prior to us having such a feel for online instruction, you know, necessity is the mother of invention. We got much better at it. Dr. Martirano and I had talked about this idea. My concern is that what teachers are required to do right now in a paper way is establish emergency lesson plans at the beginning of the year that'll for 2 or 3 days in your classes. But we do it in September, and they rest in an archive somewhere, department chairs, and they're to come out only in the most dire of situations where nobody knows what to do with your class and it will keep them busy. And as a math teacher, for example, I put something in there that we were sure to cover in September, and they would go back and do it, and kids would recognize it as busy work. And so if you start allowing paper packets, what happens then is teachers have to keep, if I had done that with emergency lesson plans in a more active way, I would have had to have updated those plans each week. And that would have meant that I would have had to construct a group of plans for the following week in a different way than my normal lesson. And they would then require updating regularly, and they may never get used. And so unless somebody's very vigilant about having those paper packets run off and updated and ready to go, and I don't know where that comes from, that sort of impetus comes from, I fear that they'll either present a strong burden, or they won't be really relevant when they go home. So I do have concerns about them in that way. We could try to avoid that, but I'm afraid we'd find ourselves in that situation.
Our paper packets are produced by central office, so ours are not. So what Dr. Delegate Ebersol is talking about.
Appreciate that. There
is you're welcome. Is more like if I'm out as a teacher, right? I taught math as well, so if I'm out as a teacher, I have sub plans, right? And those can kind of kick in whenever I'm like just can't make it for the day. But the paper packets that central office has are in lockstep with what's happening in real time with the pacing guide of the classroom, right? Everybody is kind of on the same pace, moving through the county, teaching in the county. And so those paper packets are actually more in line with what's happening real time, as opposed to
they
the
photocopied and
teacher.
kept up to date every week at a school, or every couple of days at a school? Or
They're on Canvas. They're electronically, like these are like more electronically delivered instructions, so that they're not just like in a filing cabinet somewhere.
So we have different definition, I think, in Delegate Terraza's amendment of what a paper packet is. I think we think of a paper packet, and maybe I'm thinking of it incorrectly, and maybe this is not what you mean in the bill, but a paper packet to me is something that a student carries home. Particularly, you'd need this because there are some students who don't have access to the internet in their houses. And so I have this vision of trying to deliver to students packets. Your school looks like it's going to close. We're closing down due to the pandemic. Pick up your paper packets on the way out of school today, because you're not coming in for the next several days. So I don't know why we're calling them paper packets if they're being delivered on Canvas.
Delegate Ebersol.
I'm sorry, you popped my cork there, Madam Chair.
Yeah. No, but I think I'm just wondering whether we need to name any of that. I know that Jessica Feldmark, Delegate Feldmark, had a thought, and that's relevant to this. So I'll go ahead and cede my time to her.
Great.
Yeah, go ahead, Delegate Feldmark.
Thank you. So my question is, and it's probably a question for delegation council, but my read of this provision is we could just end the sentence before including, and it would not change the impact. You know, the including through virtual classrooms, paper packets, or other learning experiences that do not provide in-person instruction is descriptive. It does not change the impact of the legislation. So I mean, we could just be silent on that. It doesn't take any of those options off the table, but I'm not sure if it makes others more comfortable. But I don't know, Dara, could you comment on that? Am I reading that correctly?
That was actually, I was going to ask a similar question, that if somebody wanted to have an amendment drafted that took out paper packets, would it be that paper packets be expressly excluded, or that we just not be, expressly mentioning them? Because I think other learning experiences, in particular, that's quite comes with a kind of catch-all phrase there. But yes, you are correct that this inclusive language is not, really limiting. It's more including these measures, but other learning experiences that do not provide in-person instruction. I would need to kind of maybe think about it, but I do think that taking that language out wouldn't really narrow the scope of this clause. It would just be less clear, perhaps. But
may I comment?
Yeah, go ahead, Dr. Martirano.
I would prefer that I agree if you take out classroom learning packets, because that is so specific, and leave in the words other learning experiences that do not provide in-person instruction, and then link that to the fact that that would be defined in the policy of the Board of Education to develop and consider other learning alternatives specifically in that policy. I think the number 1 and number 2 of the actual bill help us and keep it general enough that that could be provided in the policy by the Board of Education.
Delegate Watson, do you?
I was just going to
thoughts on
say, I like that approach. And I know that we need to move on to the orphans court, but what I would suggest, there's a few things I want to say, but what I would suggest is that we hold this till next week and work on an amendment similar to what Dr. Martirano suggested. But what I did want to say was, with regard to shutting down of individual schools, I mean, we do have cases where we have, a third of the county is out of electricity due to a storm that may last for multiple days. And rather than shut down the entire system, it would be beneficial, I think, to be able to shut down a portion of the school system rather than have all of the kids off from school. So I would think that we would want to leave the ability in there to do that. Second, with regard to Delegate Novotny's comments on working parents, I mean, if we have to shut down the schools, we're going to be affecting working parents, regardless of whether or not the kids are in instruction. So there's going to be disruption to working parents either way, I guess is my point. And I just want to remind us that the point of this bill is to keep instruction going so we don't have so many interruptions in instruction. So this is really beneficial for the kids overall and have continuous instruction. Further, it's true that we don't have this in the rest of the state, but it would be good if a jurisdiction like ours could pilot it, which is what this legislation would allow us to do. And then the last thing is the provision that we must work with the teachers to come up with a collaborative agreement, I think is crucial to this bill, because it is the teachers who have to deliver, the teachers who have to prepare, and to do it without that provision in here, I would not be supportive of. So I think that's an important provision as well. So with that, I would suggest that we hold this and work on an amendment unless anyone has any, further objections or points they want to make with regard to that amendment.
Delegate Hill, you have your hand up. Is it?
Yes, thank you. To that
point?
Yes, thank you, Mr. Chair. So again, as you're looking at amendments, please look to see if there is clarifying language to allow for the school system to adjust the way that they have traditionally done home and hospice, because this is a tool that can really make that program better. Thank you.
All right, thank you, Delegate Hill. There's been a request to hold this until the next meeting of the delegation. Seeing no objections, we will do that. Next, I think we are going to Howard County 6-22. Chair Watson, do you want to?
Sure. Yes, this is the Circuit Court for Howard County judges sitting as orphans court, and this would be Delegate Atterbury's legislation. So Delegate Atterbury, would you like to kick it off?
Yes. Can you hear me?
Yes.
Okay, this computer goes in and out. Ways and means, we got some funky broadband going on down here. So thank you, Madam Chair. So as a reminder, we started talking about this last week. This bill would be a constitutional amendment and align Howard County with Hartford County and Montgomery counties, and incorporate our orphans court into the caseload of the circuit court. And thereby default, all of the judges are already barred members of the state bar, which would put us in line with Baltimore City and Baltimore County and Prince George's County in terms of having attorneys and members of the bar look at our estates and trust matters. I do want to mention just a couple other quick things, and then I have a question for our Register of Wills who's joined us today. Thank you. So last week, I did misspeak, and I called our Register of Wills right after about where he got the information in terms of the increase in caseload. I said on here it was from Judge Tucker, which I apologize to him. I know Judge Tucker, and I have much respect for him. Apparently sent a flurry of folks to his office asking if he had spoken with folks, but no, our Register of Wills got that information from the data in the clerk's office, which he will share with you, which shows that it'll be 1.9% increase in the caseload to 1.93% increase in the caseload of the circuit court. Currently, our orphans court judges meet once a week on Wednesdays, which also speaks to the caseload. I also want to address another point just for clarification. So the purpose of the task force was to look at the entire state. And it was information was sent by one of the orphans court judges saying that there was not a recommendation to abolish the orphans court in Howard County, because that was not the purpose of the task force. The purpose of the task force was to look at statewide solutions, and one of the statewide solutions was to establish a cross-jurisdictional probate court for the smaller jurisdictions, and that will be legislation coming from some of the members in the Senate who were on the task force. That is for the smallest jurisdictions. The conversation that was had in the task force was that Central Maryland, including Howard County, have different caseloads, have different demands, and should align themselves similarly. So we will not, as Howard County, be included in this cross-jurisdictional probate court situation. I just want to remind everybody that was mentioned last week too, we are only one of 15 states that still uses this type of system of probate courts. 36 states have incorporated estates and trust matters in their current trial courts. And with that, Madam Chair, if I could ask our Register of Wills to just speak to the caseload data that he has shared with me with this group.
Well, good morning, Delegate Atterbury and members of the delegation. I appreciate having just a few minutes just to go over some of this information with you. I've gone back and I've looked at the caseload, and this is all public information, the caseload for the circuit court and for the orphans court in Howard County over the last 10 years. And from fiscal years 2012 through 2017, the caseload, the new proceeding caseload in both of these courts has been pretty consistent. There was a slight uptick in fiscal 2018. I am told mainly because of the financial crisis and an uptick in foreclosures. And since then, the caseload has actually gone down. Again, I am told that is in part because of COVID, that the caseload has dropped. And it's actually not just in Howard County, it's across the state. The circuit court caseloads have gone down. We have similarly seen a slight uptick in cases that are basically what we call regular estates that are at least $50,000. Those are pretty much the only estates that go before the orphans court. We've seen a slight uptick in that, and that's also because of COVID. When you think about it, most people pass away, frankly, when they're in old age. Most people don't pass away when they're 50 or 60. And when we had almost 300 people in Howard County die from COVID, a lot of those folks were in their 50s and 60s and 70s. And when you think about it, when is your net worth greatest? It's when you are about to retire or right after retirement. And so we had a slight uptick. And if we've looked at our caseload so far this fiscal year, it's already started to go back down. So I think that actually fiscal 2021, if we looked at fiscal 2021, the caseload increase for the circuit court would be 5%. But if we look at the sort of baseline trend that we saw for a very long time that I think that we'll get back to, it's more like 2 or 3%. The last number, and this is the number that Delegate Atterbury said, the last time I looked at these numbers was fiscal 2018, and it was right around 1.9%. So we're not talking about a big increase. And I also just really want to clarify, because I think there's confusion about the kinds of cases that go before the orphans court. The vast majority of these cases are simple administrative matters where they're signing off on a petition to probate a copy of a will, to sign off on an administration account in an estate that my staff have already audited. It is routine desk work for the most part. And it's also important to note that, as far as an impact on the circuit court, they're already handling the most complex cases that come before the orphans court. It is really kind of perverse when you think about it, that we have a specialty court to handle probate matters. And when you think of the most serious kinds of matters that would come before a probate court, for example, someone challenging the validity of a will, that has never been heard in the orphans court. It is always transferred to the circuit court. So they're already dealing with kind of our most complex cases. The clerk of court actually asked me after this bill was filed, he said, how much work is this going to be for me? And I said, it's actually going to be less work. Because you already are dealing with some of these cases as it stands now. So, and of course, appeals from the orphans court go to the circuit court as it stands now. In the future, if the circuit court sat as the orphans court, those appeals would go to the Court of Special Appeals. So that is the change in caseload as briefly as I can put it. And I'm happy to answer any other questions.
Chair Watson, you want to call on the next?
I'm sorry, I thought you were chairing.
Oh,
But you're
no,
right,
that's
I
okay.
am. Delegate Kittleman.
Thank you, Madam Chair. I apologize for the background noise. Yeah, all of the things that our Register of Wills just said sound to me like rationale for keeping things the way they are. If the things that they do are merely perfunctory or they're very easy, simple, administrative, there's no need to have lawyers doing it. And particularly that last thing about if we no longer have the orphans court to send the ones to the more complex ones to the circuit court, that they would now have to go to the Court of Special Appeals. It seems to me that we are just going out of our way to create more work for the courts that we know are always overloaded. The other thing that I wanted to ask Delegate Atterbury is, I didn't read the 179-page report, but I did look at all of the recommendations, and the recommendations, the generic recommendations were not to disband the orphans court. And I don't even think they suggested that they all be lawyers. I don't recall in front of me exactly what their recommendations were, but it was not anything that we are suggesting in this bill.
So if I can respond, Madam Chair. So I had Delegate Kittleman just finished saying that the task force was looking at statewide solutions and not county specific. The only, I guess, county centric solution that the task force recommended was a cross jurisdictional solution for your smaller jurisdictions like the ones on the Eastern Shore. There was a lot of discussion in the task force that Central Maryland should be similar. But the purpose of the task force was to look for, quite frankly, if there was a one-size-fits-all solution for the state, and the decision was no, there's not, perhaps there is something that all of the smaller jurisdictions can do that are located close to each other, and then the larger Central Maryland counties should be similar.
Could I just ask again why we want to do this?
I think one, as you know, I had a bill in several years ago that would require, sorry, that's a little distracting. I had a bill in several years ago, thank you, that would require the orphans court judges to be attorneys as they are in other, like Baltimore City, Prince George's County. As a compromise, I withdrew that bill, knowing that this task force was coming. I will say to you that the task force did recommend that in the cross jurisdictional orphans court, the recommendation is that those individuals be barred and members of the bar of the state of Maryland. And so this is where we are.
I'm sorry, maybe I apologize. I'm in another meeting and I'm sitting outside the room. People are wandering by. I didn't catch what you said as to exactly why we're doing this.
Delegate Kittleman, if you don't mind, we've got other questions behind us. And Delegate Atterbury, can you repeat what you said briefly?
Thank you.
Yes. Essentially, to align us with the other Central Maryland jurisdictions to ensure that the folks who hear these cases are barred, which is in fact a recommendation for the smaller jurisdictions for the cross-jurisdictional probate court. That is in fact a recommendation from the task force.
So no reason that stems from anything that is going wrong.
Well, there was a lot of things statewide that were discussed in the task
I'm talking about
force.
Howard County.
Well, we had a public hearing, quite frankly, Delegate Trent, where things were discussed that were going wrong. I'm not going to reiterate the whole public hearing, but some people did come in and testify, and that testimony is on the drive for you to look at, where people had concerns about the orphans court. So yes.
Okay, thank you.
Madam Chair.
Thank you. And Delegate Hester, and then Delegate Hill.
Thank you, Senator Watson.
Oh, whatever.
I had to lighten the mood just a little bit. I have a few questions for our Register of Wills. I mean, I think to Delegate Kittleman's last point about what the problems are, what I've heard is it's very difficult for attorneys to complain about things, but could we look at, could the Register of Wills respond to like what % of cases are being appealed and then with what % are being overturned and whether that's going up or down? Then I've got two more questions. Let's rattle them all off really quickly. In this report, I understand that that it wasn't a specific recommendation to abolish the orphans court, but were there previous reports that did recommend that? And the third question is, what would be the net impact on the ground? Like, would this reduce potential like government overlap or redundancy? So those are my three questions.
And those are for Byron McFarland.
Okay, let me try to answer each of those as quickly as I can. First, cost. The budget for the orphans court is about $100,000 a year. It has doubled in the last 3 years from $50,000 to $100,000. So over the course of a term, it's about $400,000, give or take, is the cost to Howard County to fund the orphans court. So that would be a savings by the county if this were to go into effect. As far as appeals go, most appeals are either settled out of court or they're dismissed on procedural grounds. They very rarely make it all the way to a substantive adjudication by an appellate court. Okay, it's usually dismissed or it's settled. That happens all the time in law. But for our court, in the last 3 years, of the appeals that have been decided on the merits, the court has been reversed twice and has not been affirmed once. And what we've seen, as Delegate Atterbury was talking about, looking at these issues statewide, we sort of have this breakdown of judges. We have 19 jurisdictions where we have 3 partisan elected part-time lay judges. Then we've got 3 jurisdictions where they're still elected, but they have to be lawyers. And then we have 2 jurisdictions where the circuit court sits as the orphans court. That's what we're talking about moving towards. In the last 3 fiscal years, again, of cases decided on the merits, in the 19 lay courts, they were reversed 50% of the time on appeal. The circuit court sitting as the orphans courts, it was 25% of the time. There were 9 affirmations and 3 reversals. Those are the facts. Those are the numbers. There's a lot of rhetoric that I've heard in discussions about this. Those are the hard numbers of what has happened over the last couple of years. The number of appeals this past calendar year, we've had a record number of appeals filed from the orphans court in the court's history. We have a number of appeals pending right now in the circuit court. One is going to be heard in March. One is going to be heard in April. I don't gamble, but I would put money on both of those being reversed because the court made egregiously bad decisions that have kept these estates open for, Delegate Kittleman wanted to know what the problem is. These are 2 estates that should have been resolved last January, but because of the court's decisions, they won't be resolved until sometime probably this summer. And that has a directly negative impact on the people of our county. I know that was a couple of questions. Oh, the other question you had was about past task forces and commissions. When I testified in favor of the task force that ended up not really doing this task force, that Delegate Atterbury talks about, was chaired by an orphans court judge. That's like putting a criminal defendant in charge of his own prosecution. So I didn't expect, and no one expected, you talk to anyone in the bar, no one expected anything substantial or anything sweeping to come out of this. But if you look at every commission and task force that has been set up in the last 150 years in our state, it has been unanimous in every single one of those reports and commissions. I think the last one was in 1992, that all of the orphans courts in the state be abolished. Not just Howard County, but all of them, that this is a system that is antiquated. I mean, we're talking about a system that was adopted from a system that existed in London in colonial days, that was subsequently abolished in London in 1850. So we have a system that is literally so antiquated and so old that it doesn't exist where we took it from. So that's why there's been a pretty consistent attitude to do away with this and move into a professionalized court. And again, as Delegate Atterbury said, Howard County is one of only 19 counties in the entire United States that uses an elected lay court to deal with probate matters. One of 19 counties out of 3,000, that's it. I hope that
Thank you
answered your
very much for
questions.
that.
All right, I'm going to go to Delegate Hill.
Thank you. Mr. McFarland, a couple of things real quick. I guess I understand that you're suggesting that there are some issues with the more complex cases, and the task force recommendation for the cross-jurisdictional was specific for complex cases. So I'm wondering, in part because I'm concerned that as you said, the vast majority of the cases that come before them are pretty bread and butter routine and can be handled, that throwing constituents, residents into the circuit court process, even if there's a judge who's rotating through what for the judge, from what you're saying, would sort of be a rubber stamp, process, it just doesn't seem like the best use of our resources. So I'm wondering why we're not talking about taking certain types of cases and sending them to the circuit court and taking them out of the jurisdictions of the orphans court. Yeah, so let's just say that's the first question. Yeah.
Yeah, so I mean, those complex cases, I mean, I guess in practice, jurisdiction over complex cases is already in the circuit court. They already handle, the orphans court does not have legal jurisdiction to determine title. So if there's ever a question about who actually owned a piece of property or a car or a bank account, that must go to the circuit court. They cannot make that decision. Again, anything complex like a will caveat, a will challenge has to go to the circuit court. It always goes to the circuit court. So you could change the jurisdiction, but then what you'd leave the orphans court with is just, you'd have a part-time court of elected officials where my office does most estates only go through us. Very few estates go to the orphans court. So you basically have orders waiting to be signed that just collect dust from week to week. And the court doesn't sit every week either. This past year, the court only sat 41 out of the 52 weeks. And so that's also a problem. So I don't think that and the idea, I think it's a novel concept, the idea of some sort of cross-jurisdictional probate court. But what was recommended by the task force, that actually would create, you would have an orphans court, you would have a cross-jurisdictional,
We wouldn't though.
some kind of specialty court, and then you'd have
the cross-jurisdictional, as I understood from Chair Atterbury, it would be for the smallest jurisdictions, and ours would either be in circuit court or the other. But what I'm hearing in your answer, and maybe I missed this and this was there before, is that what you're suggesting is that the orphans court doesn't have enough work to justify their existence, which is a different argument if I'm hearing you correctly. And if that's the case, or if you don't feel that or if the evidence is that they're not responding in a regular, predictable, and quick fashion to the cases before them, we could certainly require that they meet on a weekly basis, that no case, sit before them for longer than whatever. I mean, there are other ways to do that. The 5 recommendations for the task force, even though it was head by orphans court, was that they should be elected to 8-year terms, that they shouldn't, be affiliated with any party. And that if they're attorneys, that they don't sit on any cases or actively act as lawyers during that time that they're on the court. And then it just gets down to this piece about the complex cases. So what is
everyone, hold on one second. Delegate Hill, that's a long question. And
the question is, what is it that we're trying to,
okay.
I get it, but I'm not clear. Is it about they're not doing the work before them well? Because you mentioned, one reversal and 2 or whatever, but you didn't give me a denominator.
Yeah.
So that was how many cases?
Just hang on. I'm not, your question is understood. I just, because we're running up against a time constraint, I want you to just hold for a second, okay? And I want to give the opportunity to Judge Tucker, who is here, if there is anything that he would like us to know about this before we go forward with answering your questions. Judge Tucker, are you still with us?
Yes, I'm still with you. Can you hear me?
Yes.
Yes, well, thank you. I take no position with respect to this. I was asked to be here in case there are any questions. I have not run the numbers, so I don't know the statistics as well as you all are citing them. But from my understanding is you want to take the orphans court and let the circuit court absorb that, and that will affect the operation of the circuit court. From what I've heard just during this discussion is, yes, we do the more serious and complex cases, but if we take over the functions of them, that's going to have an effect on how we operate. I think some of the numbers quoted for last year about we had 9,000 cases in the circuit court. I'm not sure how many we're going to be handling if we have to take over the orphans court at all, but it definitely will affect how we function.
Okay, thank you. I appreciate you weighing in. We've got Byron McFarland, would you please give a succinct answer to Terry Hill, and then we will have Senator Hester, and then I'll turn it back over to Delegate Atterbury.
Yeah, I'll be very brief. Delegate Hill, I agree with the statement that they do not have enough work to justify having this judicial entity. And I would also agree that that the system that we have is inefficient and error prone. And I think that if we look at, and I think I shared this with my testimony before the delegation back in November, if we look at Harford County as an example, they resolve matters before them in half the time that our court does. And that leads to people getting resolution. I mean, something that we haven't talked a lot about in this is, how are we best serving the public? And I think that, getting resolution to, someone's death and letting them move on with their lives is really important. And if we can have a system like Harford County where they are just able to process things faster, I think that's good for the public.
Thank you.
All right. It looks like do we have one more question from Senator Lamb?
Yeah, I have one more question. So it sounds like from our discussion last week that the implementation date of this bill is that it would take effect right after it was approved by a referendum of the voters. That could essentially invalidate the election that just took place, or that would take place in November of this year. I think, I guess my hesitation about that piece is that, we would have just gone through an election, that there would have been candidates that had run and gone through a process of, campaigning and run for these offices. And then we would be deciding to no longer have them take office. And, I think there was an argument made that the folks that decide to run for these positions would know that potentially they may not be able to take office if the voters approve this by referendum in the same election that they're undergoing. My concern there is that this would affect potentially the caliber of the individuals that would run for these positions. And, somebody that may be willing to run or would be a good person to serve in this office might decide, well, I don't want to run anymore because I could put all this time and effort into it. And then in the same election that I get elected in, this whole thing could be invalidated at the same time. And so, I don't know how often voters in Howard County don't approve of a referendum that's put before them, but I do have that concern. I'm wondering if there's an openness to extending the implementation date to the following election, so that at least the folks that were elected in the current or the upcoming election would be able to take office, knowing that that would be the last 4-year term.
Okay, thank you, Senator Lamb. I'm turning it back over to Delegate Atterbury now.
Try to be quick because we only have a couple minutes. I would say no to that. I would like to call this for a vote. I mean, I think that it's similar in context to folks who file to run for office and boundary lines change in our situation. I think that anyone who would be willing to or want to run for an orphans court judge or any judge of that matter, I mean, they've put a lot of time and thought into it in terms of they have to give up certain aspects of their practice. I think they're aware of what's happening right here and right now. The bar section of the estates and bar section where most of these folks would come from are aware of what's happening. So I don't think that it would be a surprise to anyone in that instance. So with that, Madam Chair, I would like to move this for a vote on a favorable.
All right, the motion has been made. Is there a second?
Second.
Okay, Ms. Rubling, will you please call the roll?
Yes, Senator Lamb,
So I'm going to vote no, and I'd like to explain my vote. I think my request earlier was a very reasonable request. I think with all due respect, it's a little bit different than the boundary lines for redistricting, because people know when they're filing that those lines may change, but they also get to decide to unfile or to not run if they choose to before that election. In this instance, the candidates for the orphans court will not know the the outcome of this referendum before they have to go through an entire campaign and run for office, and then the election taking place, which could invalidate their ability to be able to take hold right then. I think this is a very reasonable request, and because it was not accepted, I'm voting no.
Delegate Watson,
Yes.
Senator Gazzoni,
Yes.
Senator Hester,
Yes.
Delegate Atterbury, Delegate Ebersol,
Yes.
Delegate Feldmark,
Yes.
Delegate Hill,
No, and I'd like to explain my vote. I first agree that the amendment would have improved the bill. And second, I'm concerned about the impact on the circuit court and how we haven't really given much thought or concern about how they're going to be impacted, and knowing that there's also, efforts to have more judges at that level. And third, I think that, appreciating how much time and effort the sponsor has put into this, I think there may be a more contoured, narrow solution to having our court work more efficiently and effectively that we could come to. So I'm going to vote no.
Delegate Kittleman,
Thank you. First, I want to say that the response by Mr. McFarland really answered a lot of my questions. There are a lot of reasons that this might be a good thing to do. I'm not ready to vote in favor of it yet, so I will vote no. But thank you very much for making it clear the different reasons that it might work. I still worry about the caseload for the circuit court. Anyway, I vote no.
Delegate Novotny,
Yes.
Delegate Pendergrass is recorded absent, and Delegate Terrasa.
Yes.
The motion passes.
Okay, thank you, Ms. Rubling. All right, delegation members, we are finished for today. Thank you for your hard work. I think we had great discussion, and we will meet next Wednesday. Look in your email for the agenda. Thanks, everybody. See you on the floor.